morning, Patrick. Thanks for coming on today.
Thank you, Jason. It's a pleasure to be here, and thank you for the invite.
So I have Patrick Kelleher, founder and owner of Patrick Kelleher Elder Care Center. So, as you know, Patrick, we deal with a lot of white-collar crime, and we deal with a lot of elder fraud, usually representing defendants, but we also want to try to help people who are out there. And we know that your primary concern, other than just being a fantastic trust and estates and elder care attorney, is really protecting elders. With the increase of elderly fraud out there, what are some of the steps that you deal with and can give people in terms of how to deal with a changing world, new scams, to protect an elder in this ever-changing world?
Right. Great question, Jason. And we taught last evening our trustee training program to our clients and our clients' children. Mostly their children serve as their successor trustees for mom and dad. So at a time in life where mom and dad are alive and not so well, their trusted helpers, typically their children, can step up into their shoes day number one and begin to manage their financial affairs as well as their healthcare medical affairs as well. So really, really important. So the first grounds of defense are for folks when at a point in their lives when they're alive and well, to work with a qualified, trusted estate elder law attorney and put together what I refer to as the Big Six disability planning, which comprises of the following very, very critically important legal documents. Number one, durable financial power of attorney. Durable financial power of attorney with enhanced elder law powers. And that document there, the client can memorialize and appoint their helpers legally in writing, pursuant to law, who's going to have legal authority to legally step into their shoes to manage their financial affairs when they're no longer able to do so themselves. What that's all about is that legal document is designed to avoid expensive and stressful trips to the probate court for things like conservatorships. So that durable financial power of attorney is key. And then, of course, the healthcare proxy to manage the medical affairs and to avoid guardianship proceedings at the probate court. The tricky thing about these, Jason, and the folks listening, is you have to do these when you possess the requisite cognitive capacity. The legal term is testamentary capacity. Under the Uniform Trust Code, an attorney needs to look at the testamentary capacity of the client. Do they have sufficient capacity to sign these legal documents so the attorney can actually pick up their notary stamp that legal document, the power of attorney, the healthcare proxy, to say, yes, Bill and Mary have sufficient capacity. They know what they're doing here. I had a case yesterday come into the office, sadly to say, no names, of course, but a young woman, 62 years of age, her daughter brought her in. This dear woman already has been diagnosed with severe dementia. And they wanted to change the framework of her estate plan from a couple of years ago. I told them that after meeting with the client that I was not able to help them at this time. The woman would probably need an independent medical exam, and I asked them to follow up on that, and I heard back from the daughter this morning. Again, no names, but she reported to me that the mom has been diagnosed with severe dementia, and they don't think they can obtain that letter from the doctor. I'm not surprised because when I was doing my basic assessment of her capacity, and there's different things an attorney can do, Jason, under the ABA, American Bar Association, APA, American Physicians Association, they came out with this really neat handbook for attorneys like myself to, when they're working with clients who are aging in place, working with the older client with diminished capacity, how to assess and evaluate their capacity. Again, we as attorneys, we're not doctors, we're not clinicians, right, but it's good to have a practice, a process to do some type of evaluation, do some type of observation of the client. Make sure you document the file like I did yesterday, and you have to make a good ethical decision whether you can help them or not. If you can't help them, the next step is the formal petition to the probate court for conservatorships. So I start with that as a foundation, so folks understand the importance of putting these documents in place when they're alive and well. If you wait until you're alive and not so well, like that dear lady yesterday, the only option is going off to the probate court, petition for a guardianship, petition for a conservatorship. Now the court has their formal processes in place. They're going to appoint guardian ad litems off the court list and conservators. They're all private attorneys who are going to charge you the estate, and it's going to get very expensive very quickly. So I often say, and I talk about in my book, avoid the stresses and messes of probate court. Avoid the economic and emotional headaches of probate court. Put these documents in place when you're alive and well. So that's the first step right there. Now you got that foundation in place. So as clients are journeying through life, Jason,
yes,
if they are starting to slip with their cognitive abilities, whether it's vulnerable client or diminished capacity, now you have their helper, their trusted legal helper, can legally step into their shoes and start managing their own affairs.
Yes.
And as you mentioned at the beginning of today's program, is what happens when you have a bad fiduciary, a bad fiduciary child perhaps, or family friend who's acting as that attorney in fact, and they may be taking advantage of their office as power of attorney. So that's another important subject matter, sadly to say, that does occur more often than one would think.
Yeah, Pat, just kind of go back a little bit, and we're definitely going to go into that next. Just to kind of go back, I mean, the idea is that they need to tell you what they want early, right? They need to tell you what their goals are so you can plan directly around that. Because the big thing is people are like, well, why do we need a power of attorney? I feel great. The truth is, if you have a thing set up through your law firm to make sure that their goals are reached, then what can happen is also it can protect them. So mom and dad can only lose maybe that month's allowance under the trust, and they won't essentially be giving up, their entire fortune to someone over the phone. So it allows them, and I know that your law firm does a lot of different structuring. It can structure something that is helpful for their everyday life and doesn't interfere with that, while protecting in the future should someone try to scam them out of massive amount of money. So I do have two follow-up questions to that. So I know they're both big topics. But one, what if someone really doesn't have a good person to rely on, right? Like you and me are lucky enough. We are great families. We take care of our parents and elderly folks in our lives. But we're seeing a lot of people aging by themselves, right? Like for the first time probably ever, the numbers are increasing. What do you advise those clients where they may not have even a niece or a nephew or anyone that they can trust to take care of their affairs and take care of them?
Right. That's a great question, Jason. And we do run into that on occasion. Fortunately, from my experience, probably 90% of our clients will have some family member who they feel is suitable. And what I say to my clients is this. I advise my clients when they get stuck, when they get maybe paralysis by overanalysis, like who should I pick as my helper, my fiduciary, my attorney in fact, or my power of attorney? What I advise them is to make the decision that they feel is who would be the most suitable person. And I advise them that their worst pick is often better than the probate court's best guess, because the probate court, as good as they are, they're a very, very busy place and they don't get it right all the time. Right. So I try to implore upon them. It's really a counseling issue. And I say to my client, we're the expert on the law. We can teach you about the law, but you client, you're the expert on the family. Right. So we ask them in that counseling meeting, in that trust design meeting, we put everything up on a big whiteboard. We ask the client to really think and reflect upon who might be that suitable person in their lives. It's a little bit easier for the conventional family, mom and dad, Bill and Mary with 2 or 3 children, Mo, Larry, and Curly, and they got to pick their best child to be their power of attorney. Sometimes they're like, oh, gee, they know their children. They know the dynamics. They know who has the best acumen and skill set to serve in that capacity. So they say, all right, we're going to pick Mo. We're not going to pick Curly to serve as our power of attorney. But some families don't have the 3 children. Some families have no children. So they look to pick a spouse, or they look to pick a niece or a nephew. Or if they've never been married, they don't have any children, they might even not have any nieces and nephews. And then they're looking to pick a lifelong friend. We had that yesterday with Trust Design. A client lost her husband. She's a widow, and she picked a friend to be her attorney in fact. Again, her worst pick is oftentimes better than the probate court's best guess, because when you don't have anyone picked in that power of attorney, you're relying on the probate court picking someone for you. And they're going to appoint a guardian ad litem, and that's a private attorney, as we know, off the court list, and they're very experienced probate attorneys. And they're going to conduct their investigation, and they're going to report back to the judge, and the judge will eventually pick someone they feel is in the best interest of that protected person. In some cases, that's what is necessary. But my advice typically to clients, if you can at all avoid a trip to the probate court, it's going to be less stress, less money, less drama, and a lot less time where someone can legally step into your shoes day number one and begin managing your financial affairs. So sometimes when those folks don't have anyone, sometimes they got to dig deep and really reflect on, if I don't have a family member, who's the next best person in line? Do I have a trusted friend? And if they don't have that, for the folks who are wealthier, of course, always consider a professional third-party independent trustee, such as a bank. We work with some local banks that have trust departments, and they serve as trustees. They do a very, very nice job. The downside to that is the bank, of course, is going to charge a management fee, usually a percentage of the assets under management. The upside to that is the bank has insurance. So if they mess up, you're covered. And number two, they're professionally trained. And the bank usually doesn't have an expiration date or shelf life like people do. Right. So the bank, if the trustee officer retires or no longer works there, you have a backup. So the bank might be good for longevity, might be also good for money management for that family. And you can do the risk benefit analysis. But the benefit, obviously, is having professional management. And that trustee knows the magic word to say to beneficiaries, which is no, where a family trustee has a lot of pressure put on them when beneficiaries may be looking for money. When they say no, it causes a lot of drama, puts a lot of pressure on that family member, whether it's an older sibling or aunt or uncle, who's maybe acting as a power of attorney or a trustee fiduciary for a protected person.
So, Pat, I know we're short on time today. I'd love for you to come back next time to talk to us about what happens when there's a breach of fiduciary duty. But the toughest, maybe easiest question for you of the day, where can we buy your book?
Yes, sir. So the book, thank you, Jason. The book is called How to Avoid the Four-Headed Monster of Estate Planning and Elder Law. It's an easy read, it's about 100 pages. And I released this just about a year ago. And I use the four-headed monster as a metaphor for the four big things folks ought to want to avoid when creating an estate plan. Number one, probate court. Number two, the estate death tax, because Massachusetts does have a estate death tax. Number three, financial creditors and predators. Protect the assets, the inheritance for your Mo, Larry, and Curlys from times of turmoil, and create what I call family bloodline protection subtrust. And number four, of course, is long-term care, the cost of $15,000 per month nursing home. A lot of our clients are more house rich than cash. And I say, hey, Patrick, we have a house with a lot of equity in there. We'd like to do the 3 Ps I talk about in the book. We want to protect, preserve, and pass that asset down to our children as a legacy. How do we do that? And we teach you how to do that as well. So the book's available on Amazon. You can get a paperback. Number two, you can get it at Kindle on Amazon. And I just got my audio version released and approved by Amazon earlier this week. So I'm very excited about the audio version. So no excuses, folks. You have 3 modes of learning here. And they say knowledge is power. You will get knowledge from reading this book. You will get knowledge by attending one of our educational workshops in the community. But knowledge is truly not power unless what? Of course, unless you step up off the bench, get on that field and take action. Be that matriarch, be that patriarch for your family, and create that long-lasting legacy.
Well, Patrick, thank you for joining us today, and let's talk again soon.
My pleasure, Jason. Great to see you as always. Great job, and we'll talk soon. Thank you, sir.